Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes. The topics discussed regarding retirement accounts, qualified domestic relations orders, and divorce law are complex and subject to varying state laws and federal regulations. This content does not constitute legal, financial, or tax advice. Divorce and financial planning involve significant risks and long-term consequences. You should always conduct your own due diligence and consult with a licensed attorney or a certified financial planner to address your specific situation. For decades, the American retirement dream was built on a simple, unspoken agreement. You work 40 years, you contribute to your 401k, and you share that nest egg with your spouse in a quiet, comfortable sunset. But that dream is currently being dismantled by a massive, silent demographic shift that most people aren't even tracking. In the United States, the divorce rate for couples over the age of 50 has more than doubled in the last 25 years. We are witnessing the era of the gray divorce, and the single most contested asset in these legal battles isn't the family home or the vintage car collection. It is the 401k. Imagine spending 30 years meticulously balancing your portfolio, maximizing your employer match, and watching compound interest turn your monthly contributions into a seven-figure lifeline, only to realize that a single court order could instantly slash that balance by 50% or more. This isn't just a story about a breakup. It is a story about the largest redistribution of private retirement wealth in American history. If you have more than $100,000 in your retirement account, the landscape of your future has fundamentally changed. Today, we are performing a deep dive masterclass into the changing demographics of the 401k divorce. We are going to look at why high-earning millennials and Gen Zers are now facing a completely different set of legal precedents than their parents did, and how the silver splitter movement is forcing a total rewrite of the American retirement playbook. By the end of this series, you will understand the mechanics of asset division, the hidden tax traps that can liquidate your savings, and the historical trends that determine who keeps their wealth and who starts over at 65. To understand the present, we have to look at the statistical evolution of the American household. In the 1980s and 90s, the 401k was a relatively new vehicle, having only been introduced in the late 70s. Back then, the majority of divorce cases involved younger couples with relatively small account balances. The division of assets was often a secondary concern compared to child custody or the equity in a starter home. However, as we move through 2026, the 401k has matured into the primary engine of American wealth. The demographics have shifted in three distinct ways. First, we have the late-stage accumulators. These are individuals between the ages of 55 and 70 who are divorcing with peak account balances. Historical trends show that this group is increasingly opting for lifestyle over longevity, meaning they are willing to sacrifice half of their retirement security to exit an unhappy marriage. Case studies from recent legal filings suggest that for this demographic, the 401k is often the only liquid-adjacent asset of significant value, making it the focal point of intense litigation. Second, we see the rise of the dual 401k household. Unlike the traditional model where one spouse worked and the other stayed home, today's divorcing couples often both have robust retirement accounts. This creates a complex offset scenario. Instead of a simple 50-50 split of one account, attorneys must now calculate the present value of two different portfolios, often with different vesting schedules, employer match rules, and investment risks. For example, if spouse A has a 401k valued at $500,000 with a heavy concentration in aggressive growth stocks, and spouse B has $450,000 in a conservative target date fund, a simple mathematical split is no longer equitable. The tax implications of the future withdrawals must be factored into the present-day settlement, a nuance that is frequently overlooked by those without specialized financial guidance. Third, the millennial nuptial delay has created a demographic of divorcing individuals who entered marriage already possessing significant 401k assets. In previous generations, people married young with zero assets. Today, professionals often marry in their early 30s after a decade of career growth. This introduces the concept of premarital property versus community property. If you entered a marriage with $150,000 in your 401k, and it grew to $600,000 over 10 years of marriage, how much does your spouse actually own? Is it half of the total, or half of the $450,000 growth? What about the market appreciation on the original $150,000? These are the questions defining the new era of American divorce. The stakes have never been higher because the 401k is not just a bank account. It is a tax-advantaged fortress. When that fortress is breached during a divorce, the government is often the first one to take a cut. Most people assume that if a judge orders a split, you just cut a check. In reality, moving money out of a 401k normally triggers a 10% early withdrawal penalty and immediate income tax. To avoid this, the legal system uses a tool called a QDRO, or a Qualified Domestic Relations Order. A QDRO is a highly specialized legal document that instructs the plan administrator of a 401k to pay a portion of the account to an alternate payee, typically the ex-spouse. This is the only way to move 401k funds without triggering an immediate tax disaster. However, the demographic shift has shown a massive increase in QDRO failures. As companies move toward automated HR systems and outsourced plan management, the administrative hurdles to getting a QDRO approved have skyrocketed. Historical data indicates that a significant percentage of QDROs are rejected on the first attempt due to minor clerical errors or failure to align with the specific language of the employer's plan. For a divorcing individual in their 60s, a 6-month delay in a QDRO processing can mean the difference between a planned retirement and being forced back into the labor market. Furthermore, we must address the inflationary impact on divorce settlements. In a high-inflation environment, the future value of a 401k is more volatile. If a divorce settlement is reached in January, but the actual transfer of funds via QDRO doesn't happen until August, market fluctuations can lead to a shortfall dispute. If the market drops 10% during those months, who bears the loss? Does the ex-spouse still get the fixed dollar amount agreed upon in January? Or do they get a percentage of the now diminished account? This is why we are seeing a trend toward percentage-based awards, rather than dollar-specific awards in modern courtrooms. The goal of this deep dive is to provide you with the framework to understand these shifts. Whether you are currently navigating a separation, planning for the future, or simply interested in the sociological changes in American wealth, understanding the mechanics of the 401k divorce is essential. We are moving away from an era of simple alimony and into an era of complex asset partitioning. This shift reflects a broader change in the American identity, where our value is no longer tied to the land we own or the houses we build, but to the digital balances in our retirement accounts. Over the next 9 parts of this masterclass, we will break down the specific strategies used by top-tier legal teams to protect premarital assets. We will examine the Social Security offset and how it interacts with private 401k holdings. We will look at the psychological toll of retirement insecurity and how it drives aggressive litigation tactics. Most importantly, we will provide the data you need to see the big picture of how the American family is being redefined by its balance sheet. This is not just a legal process, it is a financial evolution. Stick with us as we peel back the layers of the changing demographics of the 401k divorce in America. To understand why the demographics of 401k division have shifted so radically by 2026, we have to examine the death of the pension and the birth of the self-funded divorce. In the previous era of American labor, a retirement benefit was often a defined benefit plan. You worked for a company, you retired, and a check showed up every month until you died. When a couple divorced in that era, the court simply divided the future stream of income. But today, the 401k is a defined contribution plan, a volatile market-exposed bucket of cash that represents the largest single source of liquid wealth for the American middle and upper middle class. Imagine a couple in suburban Ohio. Let us call them David and Sarah. They are both 55 years old, and they have decided to end their 28-year marriage in early 2026. David has been a mid-level executive at a manufacturing firm, and his 401k is valued at $1.2 million. Sarah has worked part-time and managed the household, with a smaller 401k valued at $150,000. In the eyes of the law in many states, that $1.35 million total is a marital asset, but the process of splitting it is where the demographic reality hits the pavement. Historical trends show that for someone like David, that $1.2 million represents 30 years of discipline, market timing, and compound growth. For Sarah, that money represents her only hope of avoiding poverty in her 70s. The tension between these two perspectives creates a high-stakes negotiation that did not exist when wealth was tied up in a non-transferable pension. This is why we are seeing a surge in what forensic accountants call lifestyle tracing. Step 1 in this deep dive is the identification of the marital portion. In 2026, the complexity of tracing contributions is at an all-time high because of how often Americans change jobs. The average worker now holds 12 jobs in their lifetime. This means David likely rolled over 4 or 5 different 401k accounts into his current plan. If any of those rollovers contain funds he contributed before he met Sarah, that money might be considered separate property. However, once those funds are commingled with marital contributions and employer matches, the burden of proof shifts to the account holder to prove what is mine and what is ours. This leads us to a critical demographic shift: the rise of the forensic 401k auditor. 10 years ago, you hired an appraiser for the house. Today, you hire a data specialist to reconstruct 30 years of 401k statements. We are seeing cases where the cost of the audit itself exceeds $20,000. But when the asset in question is north of $1 million, the potential outcomes of that audit can swing the settlement by 6 figures. Consider the impact of the employer match. In the 2026 labor market, vesting schedules have become more aggressive. If David's company contributes a 6% match that vests over 5 years, and the divorce happens in year 3 of a new job, who owns the unvested portion? Historically, courts have struggled with this, but the modern trend is to treat unvested shares as a marital asset subject to a deferred distribution. This means Sarah might not get her money today, but she gets a legal lien on those shares when they eventually vest. This creates a post-divorce financial tether that can last for years, complicating the clean break that most couples desire. Now, let us look at the Gen X demographic, the first generation to rely almost entirely on the 401k. They are currently hitting their peak earning years and, unfortunately, their peak divorce years. For Gen X, the 401k is often more valuable than the primary residence. In a high-interest rate environment like we are seeing in 2026, many couples are finding it impossible to sell the family home and buy 2 new ones because they cannot afford the new mortgage rates. Consequently, they are using the 401k as a bargaining chip to stay in the house. In a scenario we see frequently now, one spouse, let us call her Jennifer, agrees to give up her entire half of the 401k in exchange for keeping the house and its 3% mortgage from 2021. This is a massive demographic gamble. Jennifer is trading a liquid, diversified investment portfolio for an illiquid, high-maintenance real estate asset. Historical trends suggest that while this solves the immediate housing problem, it creates a looming retirement crisis for the spouse who keeps the house. They have a roof over their head but $0 in a tax-advantaged account to pay for their life once they stop working. Furthermore, we must discuss the tax-adjusted valuation of these accounts. $1 million in a 401k is not the same as $1 million in a savings account. Because 401k distributions are taxed as ordinary income, that $1.2 million account is actually worth significantly less after the IRS takes its cut. In 2026, savvy divorce attorneys are insisting on tax affecting the 401k during the division process. If the couple is in a 24% tax bracket, they might value the 401k at only $912,000 for the purpose of the asset split. This demographic of high net worth divorcees is the first to systematically apply corporate accounting principles to their personal heartbreak. Another emerging demographic is the late career gig worker. By 2026, a significant portion of the workforce has moved into high-end consulting or independent contracting, utilizing solo 401ks or SEP IRAs. These accounts have much higher contribution limits, often over $60,000 per year. When these individuals divorce, the sheer speed at which they can accumulate wealth creates a friction point. If a consultant doubles their 401k balance in the 2 years it takes for the divorce to finalize, the debate over the valuation date becomes a multimillion-dollar argument. Is the account valued at the date of separation or the date of the final decree? The answer can change a person's retirement age by a decade. We also have to account for the loans. One of the most dangerous demographic trends we are seeing in 2026 is the 401k loan-heavy household. Many families have used 401k loans to fund college tuitions or medical emergencies. In a divorce, these loans are often treated as marital debt. If David has a $50,000 loan against his 401k, that debt must be addressed in the settlement. If he leaves the company during the divorce, that loan may become due immediately, or be treated as a taxable distribution, adding a massive tax bill to an already expensive legal battle. As we look at these case studies, a pattern emerges. The 401k has transformed from a retirement tool into a weapon of legal leverage. The complexity of these accounts allows for a level of strategic maneuvering that the old pension systems never permitted. We are seeing a demographic that is more financially literate than ever, yet more vulnerable to the specific pitfalls of the tax code. But what happens when the 401k division goes wrong? What happens when the qualified domestic relations order is drafted, signed by a judge, but then rejected by the plan administrator because of a change in corporate ownership or a merger. This is a growing crisis in 2026 as corporate consolidations reach a fever pitch. Your 401k might be with Company A when you start the divorce, but by the time you finish, Company A has been bought by a private equity firm, and the plan rules have completely changed. This is the hidden trapdoor of the modern divorce. You can follow every rule, hire every expert, and still find yourself staring at a frozen account while your ex-spouse spends the liquid cash. The demographic shift isn't just about who is getting divorced. It's about the crumbling infrastructure of the financial systems that manage our wealth. As we move into the next part of this deep dive, we are going to explore the specific mechanics of the QDRO nightmare. We will look at why 2026 has become the year of the rejected order, and how the IRS is quietly changing the rules on how these transfers are reported. If you think a judge's signature is the end of the story, you are missing the most dangerous part of the process. In the next chapter, we will uncover the hidden fees and the administrative gatekeepers who can hold your retirement hostage for years. The signature of a judge on a divorce decree is often mistaken as the finish line, but for a 401k, it is merely the starting gun for a grueling administrative marathon. In 2026, the complexity of corporate bureaucracy has turned the Qualified Domestic Relations Order, or QDRO, into a high-stakes bottleneck. To understand why, you have to look at how the management of these plans has changed. Most large U.S. corporations no longer manage their own 401k plans in-house. They outsource them to massive third-party administrators who process thousands of these claims using automated algorithms. If your legal document does not mirror the exact, idiosyncratic phrasing required by that specific administrator, the system will flag it, reject it, and send you back to square one. Imagine a professional named Marcus who works for a major aerospace firm in Seattle. Marcus and his spouse, Elena, finalized their divorce in early 2026. The court ordered a 50-50 split of his $2.4 million 401k. Their attorneys drafted a standard QDRO, which the judge signed. However, during the 3 months it took to finalize the paperwork, Marcus's company underwent a corporate restructuring, shifting their 401k management from one financial giant to another. When the QDRO finally hit the desk of the new administrator, it was rejected instantly. Why? Because the new plan summary plan description required specific language regarding the treatment of outstanding loans and the valuation of company match stock that was not present in the original court order. This is the QDRO nightmare that is defining the 2026 demographic of divorce. It is no longer just about legal rights. It is about technical compatibility. When a QDRO is rejected, the clock does not stop. During the months required to amend the document, refile it with the court, and resubmit it to the plan, the market continues to move. If the S&P 500 experiences a 5% correction during that administrative delay, the actual dollar amount transferred to the ex-spouse could fluctuate by tens of thousands of dollars. This leads to secondary legal battles over who is responsible for the market loss during the delay. Historical trends show that these administrative hurdles are a primary cause of post-divorce litigation, as parties accuse each other of intentionally dragging their feet to benefit from market swings. Furthermore, we are seeing a significant rise in hidden administrative fees. In 2026, many plan administrators have instituted QDRO processing fees that range from $500 to over $1,500 per account. While that may seem small relative to $1 million balance, the real cost lies in the opportunity cost of the freeze. The moment a plan administrator receives a draft QDRO or a notice of intent to divide, they place a hold on the account. Marcus, in our scenario, would be unable to change his investment allocations, take a loan, or perform a rollover while the account is frozen. If the administrative back and forth lasts 6 to 12 months, Marcus is essentially trapped in whatever market positions he held at the start of the divorce, regardless of whether those investments still make sense for his new financial reality. Step by step, the process for an alternate payee like Elena to actually see her money is far more arduous than the public realizes. First, the attorney must obtain the plan procedures. Every 401k plan is governed by ERISA, the Employee Retirement Income Security Act, but ERISA gives individual plans significant leeway in how they handle QDROs. Some plans allow for a separate account to be created for the ex-spouse immediately, while others require the funds to be moved out of the plan entirely into an IRA. In 2026, the demographic of the silver splitter is particularly vulnerable here. If Elena is 62 and was counting on that $1.2 million to begin her retirement immediately, A rejection of the QDRO can be catastrophic. She cannot simply go to the bank and withdraw the funds. She is reliant on a third-party administrator she has no direct relationship with to approve a document she didn't write. Case studies from this year show that many individuals in Elena's position are forced to take high-interest personal loans or liquidate other non-retirement assets just to cover living expenses while the 401k transfer is stuck in administrative limbo. There is also the issue of the survivor benefit trap. This is a demographic-specific detail that often catches Gen X and Boomer couples off guard. In a 401k, the spouse is legally the beneficiary unless they sign a waiver. In the heat of a divorce, many participants forget to update their beneficiary designations. Even if the divorce is final, if the QDRO is not fully processed and the participant passes away, some plan rules may still award the entire balance to the ex-spouse as the named beneficiary, overriding the divorce decree. In 2026, we are seeing a surge in beneficiary litigation, where the children of a deceased divorcee are suing their own parent's ex-spouse to recover retirement funds that were never properly moved out of the 401k system. Let us look deeper into the data of 2026. According to recent surveys of family law practitioners, nearly 40% of 401k-related divorces involve at least one significant administrative error that delays the transfer of funds by more than 90 days. This isn't just human error, it's a systemic friction point. The financial institutions have no incentive to move quickly. In fact, keeping the assets under management for an extra 6 months benefits the institution's bottom line. This has created a new cottage industry of QDRO specialists, paralegals and financial analysts who do nothing but navigate these specific corporate labyrinths. Imagine if the account in question isn't just a standard 401k, but a solo 401k for a small business owner. In this demographic, the participant is often their own plan administrator. This sounds like it would make things easier, but it actually increases the risk of IRS scrutiny. If a business owner moves money to an ex-spouse without a perfectly executed QDRO that meets federal standards, the IRS may view that transfer as a standard distribution. Potential outcomes here include the business owner being hit with a massive tax bill, and the ex-spouse receiving tainted funds that cannot be rolled into an IRA. The complexity of these scenarios is why we are seeing a shift toward asset swapping in modern settlements. Instead of dealing with the QDRO nightmare, many couples are choosing to trade the 401k for other assets of perceived equal value. For example, if a couple has a 401k worth $800,000 and a brokerage account worth $600,000, one spouse might take the entire brokerage account and a smaller portion of the 401k to simplify the process. However, this requires an incredibly accurate, tax-equivalent valuation. You cannot trade $1 of 401k money for $1 of brokerage money because the brokerage money has already been taxed, whereas the 401k money carries a massive future tax liability. In 2026, the demographic that fails to account for this embedded tax is effectively losing 20 to 30% of their net worth without even knowing it. As we examine the administrative gatekeepers, we must also look at the rise of the international QDRO. With more Americans working for global firms, many 401k plans are now tied to multinational entities with complicated jurisdictional rules. If Marcus's aerospace firm was headquartered in London or Tokyo, but he was contributing to a US-based 401k, the intersection of treaty law and ERISA adds yet another layer of potential failure. The administrative landscape of 2026 is a minefield of lost data. As companies merge and switch digital platforms, historical contribution data, which is essential for proving premarital portions, is frequently lost or archived in inaccessible formats. This forces divorcing parties into a best-guess negotiation, which rarely ends in a truly equitable split. The 401k is no longer a simple savings account. It is a complex legal entity that requires a specialized set of keys to unlock. If you don't have those keys, your retirement is effectively a digital phantom. But what happens when the 401k isn't just cash and mutual funds? What if it's filled with company stock that is currently in a blackout period due to a merger? Or what if it contains alternative assets that are illiquid? In the next part of this masterclass, we are going to dive into the most volatile part of the 401k divorce: the valuation and division of company stock and the hidden assets that spouses try to shield from the QDRO process. We will uncover how NUA or net unrealized appreciation can be either a massive tax windfall or a devastating trap depending on how the divorce decree is worded. The complexity of the 401k division reaches a fever pitch when the assets are not just diversified mutual funds, but concentrated blocks of company stock. In 2026, many high-earning professionals in the tech and pharmaceutical sectors have 401k plans heavily weighted in their employer's equity. This introduces one of the most powerful, yet dangerous tax strategies in the American Retirement Code: net unrealized appreciation, or NUA. If you do not understand NUA during a divorce, you are effectively flying a plane through a storm without a radar. Imagine a software architect named Leo who works for a major cloud computing firm in Austin, Texas. Over 15 years, Leo has used his 401k to buy shares of his company's stock. The cost basis, the price he actually paid for those shares, is $200,000. However, by early 2026, the market value of that stock has ballooned to $1.2 million. If Leo were to roll that stock into a traditional IRA, every dollar he eventually withdraws would be taxed as ordinary income, which could be as high as 37%. But under NUA rules, if he takes a lump sum distribution of the stock, he only pays ordinary income tax on the $200,000 cost basis. The $1 million of growth, the unrealized appreciation, is taxed at the much lower long-term capital gains rate, which is typically 15 or 20%. In a divorce, NUA becomes a demographic battleground. Imagine Leo's spouse, Maya, is awarded half of the 401k. If the divorce decree and the resulting QDRO are not meticulously worded to preserve the NUA treatment for her portion, Maya could lose out on hundreds of thousands of dollars in tax savings. Historical trends show that most general practice divorce attorneys are unaware of NUA nuances. If the stock is rolled over into an IRA by mistake as part of the settlement, the NUA tax advantage is permanently destroyed. It cannot be undone. Case studies from 2025 and 2026 highlight a growing number of malpractice lawsuits filed against family law firms specifically for failing to identify and protect NUA opportunities during asset partitioning. Step by step, the division of company stock requires a level of precision that standard cash split QDROs do not possess. First, the administrator must be able to track the specific lots of stock. If the plan administrator cannot distinguish between stock bought in 2012 versus stock bought in 2024, the NUA calculation becomes impossible. Second, the distribution must be a total distribution of the participant's balance within a single tax year. If Leo keeps some funds in the 401k and Maya moves her portion out, the NUA eligibility for both parties could be jeopardized depending on the plan's specific architecture. This is why we see a demographic of savvy divorcees in 2026 hiring specialized tax counsel alongside their divorce lawyers just to handle the 401k equity component. Beyond the tax strategy lies the darker reality of the hidden 401k. While 401k accounts are generally transparent because they are linked to Social Security numbers and employer records, the demographic of the high net worth entrepreneur has found ways to obscure the true value of their retirement holdings. We are seeing a rise in what is known as the shell rollover. Imagine a scenario where a spouse, let us call him Robert, decides to divorce in 2026. Months before filing, he rolls over a significant portion of his corporate 401k into a self-directed solo 401k under a newly formed LLC. He then uses those funds to invest in non-traditional assets like private equity or physical gold, held in a specialized depository. When the discovery process begins, Robert produces a statement for his current corporate 401k showing a much lower balance. Unless the other spouse's legal team is trained to perform a multi-year audit of rollover history, that moved capital can essentially disappear from the immediate negotiating table. In 2026, forensic accountants are increasingly using digital trail analysis to track these transfers. They look for the 1099, or forms that must be generated when money leaves a corporate plan. However, the demographic shift toward decentralized and self-directed retirement vehicles has made this cat-and-mouse game more complex than ever before. Another layer of this evolution is the valuation of alternative assets within a 401k. By 2026, it is not uncommon for self-directed 401k accounts to hold fractional shares of commercial real estate or private credit funds. Unlike a share of Apple or Microsoft, these assets do not have a daily ticker price. If a divorcing couple needs to split a 401k that holds a 5% stake in a private medical office building, they face a valuation nightmare. Historical trends show that these assets are often undervalued by the spouse in control of the account, and overvalued by the spouse seeking a split. This results in valuation lock, where a divorce cannot finalize for years because neither side can agree on what the retirement account is actually worth today. We must also consider the demographic impact of the catch-up contribution era. The Secure Act 2.0 and subsequent 2026 regulations have allowed older Americans to shovel significantly more money into their 401k accounts as they approach retirement. For a couple in their late 50s, this means the account balance can swing by $30,000 to $50,000 in a single year just from contributions and employer matches. If the date of separation is set in January but the divorce isn't final until December, the question of who owns that final year of massive catch-up contributions becomes a primary point of contention. Is it marital property because the marriage still legally existed, or separate property because the parties were living apart? This leads to the liquidity trap of 2026. In many modern divorces, one spouse is cash poor but 401k rich. Imagine Sarah, who has been a stay-at-home parent for 20 years. She is awarded $500,000 of her husband's 401k. She needs cash now to pay for a security deposit on an apartment, a new car, and legal fees. However, that $500,000 is locked behind the 401k wall. If she takes it out, she pays taxes. There is a specific historical trend involving the 72T distribution, which allows for substantially equal periodic payments to avoid the 10% penalty, but it requires her to commit to a 5-year withdrawal schedule. Most people in Sarah's demographic are unaware that a QDRO-triggered distribution allows the recipient to take a cash payout without the 10% early withdrawal penalty, though they still owe the income tax. Failing to know this one specific rule can lead people to take high-interest credit card debt instead of accessing the funds they just won in court. As we look at the changing face of these battles, we see that the 401k is being treated less like a retirement fund and more like a severance package for the marriage. The demographic of 2026 is less concerned with the long-term growth of the fund and more concerned with the immediate utility of the capital. This short-term thinking is creating a generation of divorcees who may have won the legal battle, but are entering their 70s with significantly depleted portfolios due to tax mismanagement and the costs of litigation. The 401k is a fortress, but in 2026, that fortress is being dismantled brick by the legal system. The question isn't just about how much you have, but how much you can actually keep after the QDRO, the IRS, and the forensic auditors have taken their turn. But what happens when the 401k isn't the only retirement vehicle? What if there are dark pensions or executive non-qualified deferred compensation plans that don't follow the same rules as a 401k? In the next part of this deep dive, we are going to look at the executive tier of divorce. We will explore how golden parachutes and deferred compensation plans are hidden from standard discovery, and why the rules we just discussed for 401ks do not apply to the wealthiest 5% of Americans. If you think a QDRO is complicated, wait until you see how the C-suite handles a breakup. We are moving from the 401k to the world of shadow retirement, where the real wealth is often tucked away in contracts that a standard divorce court can barely reach. As we move beyond the common 401k, we enter the world of shadow retirement. In 2026, the demographics of the American C-suite and high-tier management levels have shifted toward increasingly bespoke and complex compensation packages. While the average worker relies on a qualified 401k plan, the top 5% of earners often have the majority of their retirement wealth tied up in non-qualified deferred compensation, or NQDC, and supplemental executive retirement plans known as SERPs. These are the hidden engines of wealth that a standard divorce attorney might miss because they do not appear on a traditional 401k statement. To understand the scale of this, imagine a high-level executive named Thomas, who works for a multinational tech conglomerate in Silicon Valley. Thomas has a 401k with the maximum allowed balance of around $1.5 million. On paper, during a divorce from his spouse, Elena, this $1.5 million looks like the primary retirement asset. However, Thomas also has an NQDC plan. Because NQDC plans have no IRS contribution limits, Thomas has been deferring 50% of his $800,000 salary and 100% of his $400,000 annual bonuses into this shadow account for a decade. The actual value of his retirement isn't $1.5 million. It is closer to $12 million. The demographic shift in 2026 shows that these plans are becoming more common not just for CEOs, but for VPs and even senior directors as companies compete for talent. But here is the critical demographic trap. NQDC plans are not protected by ERISA, While a 401k is a trust that belongs to you even if your company goes bankrupt, an NQDC is technically just an unfunded promise to pay. It is an asset of the company. If the company fails, Thomas and Elena could lose everything in that account. Historical trends in executive divorce cases from 2024 to 2026 show that courts are struggling with how to value this risk. Is $1 million in a guaranteed 401k worth the same as $1 million in an NQDC that could vanish if the company hits a rough patch? Plus one. Step by step, the division of a shadow plan is a legal tightrope. You cannot use a QDRO for an NQDC plan. QDROs only apply to qualified plans. Instead, the division must be handled through the divorce decree itself or a specific letter of instruction to the company. Case studies from recent high net worth filings indicate that many companies refuse to split these accounts at all. They may tell Elena, "We have a contract with Thomas, not you. We will not create a separate account for you." In this scenario, Elena is left as a judgment creditor of her own ex-husband. She has to wait for Thomas to retire or reach his distribution date, and then hope he pays her the half she was awarded. If Thomas decides to move to a country without an extradition treaty or simply spends the money, Elena's legal recourse is limited and expensive. This has led to a 2026 trend where non-employee spouses are demanding offsetting assets. Elena might say, "Keep the $12 million deferred compensation plan, but I'm taking the $6 million primary residence and the $2 million brokerage account today." However, this brings us back to the tax equivalent valuation problem we discussed earlier, but on a much larger scale. NQDC distributions are taxed as 100% ordinary income. If Thomas is in the highest tax bracket in 2026, that $12 million is actually worth about $7.5 million after taxes. If Elena takes $6 million in clean after-tax assets like a house, she has effectively won the financial war, while Thomas is left holding a massive tax bill and a high-risk corporate promise. Furthermore, we must look at SERPs. These are essentially top-hat pensions designed to give executives a specific percentage of their final pay for life. In 2026, many of these are being structured as notional accounts. Imagine if Thomas's SERP is valued at $500,000 per year for life starting at age 65. How do you divide that in a divorce when he is only 52? You have to hire an actuary to determine the present value of that future stream of income. This calculation is a demographic battleground. The actuary must guess how long Thomas will live, what the future inflation rate will be, and what discount rate to apply to bring those future dollars into today's value. A 1% change in the discount rate can swing the valuation of a SERP by over $1 million. The data from 2026 also shows a rise in non-compete retirement forfeiture. Many executive plans state that if Thomas leaves the company to work for a competitor, he loses his entire NQDC balance. If the divorce settlement requires him to pay Elena half of that balance, but then he gets headhunted by a rival firm and loses the account, he is still legally obligated to pay Elena for an asset that no longer exists. This is why clawback clauses are now being written into divorce decrees for the upper middle class. We also see the double-dipping controversy. This occurs when a court treats the executive's deferred compensation as both an asset to be divided and income for calculating alimony. If Thomas is receiving $200,000 a year from an old NQDC plan, and the court gives Elena half of that as property division, can they also use that same $200,000 to say Thomas has the ability to pay $50,000 in monthly support? In 2026, several high-profile appeals in New York and Connecticut have set new precedents to prevent this double counting, but it remains a primary source of confusion for couples who are self-navigating their split. As we move toward the middle of this masterclass, the picture is becoming clear. The higher you go on the corporate ladder, the less the standard rules of divorce apply. The 401k is just the tip of the iceberg. The real bulk of American retirement wealth for the influential class is submerged in contracts, vesting schedules, and corporate liability. But what if the money isn't just deferred? What if it is tied to performance? What if Thomas's retirement depends on the company's stock hitting a certain price in 2028? In the next part of this series, we are going to look at the performance trigger divorce. We will examine how restricted stock units, RSUs, and performance shares are divided when the value is 0 today, but could be 50 million tomorrow. We will uncover the golden handcuffs and how they are used to trap ex-spouses in legal battles that last a decade. If you think the shadow retirement world is complex, the equity performance world is where the true fortunes are made, and lost in the American divorce court. The shift from stable 401k balances to the high-stakes world of performance-based equity marks the most volatile transition in modern American divorce demographics. In 2026, we are seeing a massive trend where mid to upper-level employees are no longer just rewarded with a salary and a match. They are bound by golden handcuffs. These are restricted stock units or RSUs and performance stock units or PSUs. Unlike a 401k, which contains realized assets, these equity vehicles represent a future possibility. They are the financial equivalent of a mirage that only turns into water if you stay with the company long enough. This creates a demographic of divorcing professionals who are technically millionaires on paper, but may have zero liquidity to pay for a legal defense. Imagine a lead engineer named Michael who works for a robotics firm in Boston. It is mid-2026, and Michael's compensation package includes $400,000 in RSUs that vest over a 4-year period. He is currently in year 2 of his marriage's dissolution. His spouse, Sarah, naturally claims that because these units were granted during the marriage, they are marital property. However, Michael argues that because he hasn't actually received the shares yet, and won't until he completes 2 more years of labor, the value should be considered separate property earned after the divorce. This is the performance trigger battleground. In the legal landscape of 2026, courts are increasingly using what is known as the Nelson formula or the DeCastro rule to solve this. This involves a time-weighted fraction. You take the number of months from the date of the grant to the date of marital separation, and divide it by the number of months from the grant to the date of vesting. The resulting percentage determines the marital share. For Michael, this means a massive portion of his future wealth is already spoken for by a legal decree, even if the robotics company goes under before he ever touches a cent. Historical trends show that this calculation often leads to a paradox of wealth where the employee spouse is forced to stay in a job they hate just to ensure the shares vest, because if they quit, they might still owe their ex-spouse the value of those forfeited units based on a court's previous valuation. Furthermore, we must address the demographic of the performance stock unit. PSUs are even more complex than RSUs because they don't just require you to stay at the company. They require the company to hit specific goals. Imagine Michael's PSUs only vest if the company's stock price doubles by 2028. How does a divorce court in 2026 value a 50% chance of a $2 million payout? Case studies from this year show a rise in the use of the co-ownership model. Rather than trying to put a dollar value on the shares today, the court orders that Sarah will simply receive a percentage of whatever Michael eventually receives, if and when he receives it. This effectively turns ex-spouses into involuntary business partners for years, or even decades after their divorce is finalized. This brings us to the demographic of the invisible equity. In the current 2026 economy, many startups are staying private longer. Employees at these firms hold stock options that have no public market. If a couple divorces while holding options in a private unicorn worth $10 billion, they cannot simply sell the shares to split the cash. They are stuck in a liquidity vacuum. We are seeing a trend where spouses are forced to enter into complex constructive trusts. In this scenario, Michael holds the options in his name, but he is legally bound to exercise them on Sarah's behalf the moment a liquidity event, like an IPO or acquisition, occurs. Historical trends suggest these trusts are a breeding ground for future litigation, especially if the employee spouse forgets to notify the ex-spouse of a secondary market sale or a tender offer. The data for 2026 reveals another critical shift: the tax shifting of equity awards. RSUs are taxed as ordinary income at the moment of vesting. If Michael vests $100,000 in stock, his company will likely sell about 30 to 40% of it immediately to cover federal and state taxes. If Sarah's divorce attorney doesn't account for this, and the court awards her 50% of the gross shares, Michael could end up with nearly nothing after taxes are deducted from his remaining half. Savvy legal teams are now drafting net of tax clauses that ensure the burden of the IRS is shared equally between the parties. Without these clauses, the high earner in the 2026 divorce demographic is essentially being taxed on wealth they are handing over to someone else. Beyond the technicalities of vesting and taxes, there is the psychological impact of the golden handcuffs on the divorce process itself. We are seeing a demographic of spouses who intentionally delay the finalization of their divorce to cross certain vesting milestones. Conversely, we see companies that, aware of an executive's high-profile divorce, might shift compensation away from transparent 401k matches and toward more opaque performance bonuses or discretionary equity grants. This creates a shadow discovery process where forensic accountants must look beyond the W-2 and examine the actual grant agreements and board minutes of a corporation. Step by step, the division of performance equity in 2026 requires a three-pronged approach. First, the characterization. Is it for past service during the marriage or an incentive for future work? Second, the valuation. Is it a fixed dollar amount or a percentage of future shares? Third, the transfer. Will the company allow a direct transfer of shares to an ex-spouse, or must it be handled as a cash payment from the employee? Most corporate plans in 2026 strictly prohibit the transfer of RSUs to anyone other than the employee, which means the employee spouse is often left with a massive debt they can't pay until the stock market cooperates. As we look at these case studies, it becomes clear that the 401k was the simple part. The 401k was the baseline. The real struggle for the American professional class is now centered on these contingent assets. The demographic that relies on equity is growing, and with it, the complexity of the American breakup is reaching an all-time high. We are seeing people in their 40s and 50s who have a net worth of $5 million but a bank account balance of $5,000 because everything is tied up in unvested triggers. This leads us to a looming crisis that the legal system is only just beginning to address. What happens when the performance triggers fail? In a volatile 2026 market, many of these equity-heavy compensation packages are ending up worthless. If a divorce settlement was based on the potential outcome of a stock hitting a certain price, and that price is never reached, the entire financial structure of both ex-spouses collapses. The wealth that was divided simply never existed. But what if the money isn't just tied to stock? What if it's tied to the person? In the next part of this masterclass, we are going to dive into the most controversial demographic of all, the celebrity and influencer divorce. We will explore how brand value and future earning capacity are being quantified in 2026, as if they were a 401k. We will look at how a YouTube channel's projected revenue or a TikToker's likeness rights are now being split in courtrooms from New York to Los Angeles. If you thought splitting a stock option was hard, wait until you see how they divide a human being's digital soul. The intersection of intellectual property and retirement is our next stop. The transition from tangible assets like a 401k to the intangible realm of intellectual property and digital personas represents the final frontier of the modern American divorce. In 2026, we are seeing a demographic shift where the primary engine of retirement isn't just a portfolio of stocks, but a portfolio of rights. For the modern creator, influencer, or entrepreneur, their retirement security is often inextricably linked to their personal brand, their digital library, and their likeness. This has created a phenomenon we call the digital soul divorce. Imagine a creator named Jordan who has spent the last 8 years building a massive educational YouTube channel and a suite of digital courses focused on sustainable engineering. By 2026, the channel generates $3 million in annual revenue through a mix of ad share, sponsorships, and evergreen course sales. Jordan's spouse, Taylor, has been the behind-the-scenes support, managing the household and occasionally appearing in the background of videos. When they file for divorce, the question isn't just about the cash in the bank. It is about the 401k equivalent value of that channel's future earnings. Historical trends in California and New York courts suggest that a digital platform built during a marriage is a marital asset. But how do you value it? Unlike a 401k balance that you can check on an app, a digital brand's value is based on projected human performance. We are seeing forensic accountants in 2026 using discounted cash flow models to put a price tag on a person's future output. If Jordan is expected to create content for another 20 years, the court might value the goodwill of that brand at $10 or $15 million. Step by step, the division of a digital soul is a logistical nightmare. The first step is the audit of contribution. Taylor's legal team will argue that without Taylor's domestic support, Jordan would never have had the time to film. They will look for emails, Slack messages, or any digital trail that proves Taylor acted as a de facto producer or advisor. If Taylor is awarded 50% of the brand's value, Jordan faces a terrifying reality. They must either pay Taylor millions of dollars in cash today or pay Taylor a percentage of every video they film for the rest of their career. This leads to the demographic of the creative captive. We are seeing creators in 2026 who are effectively working for their ex-spouses. If Jordan is ordered to pay Taylor 30% of all future gross revenue from the channel, Jordan's incentive to innovate or work hard is severely diminished. Why spend 80 hours a week on a high-production video when a third of the profit goes to a person they are no longer married to? This is the tax on talent, that is redefining the creative class. In several case studies from early 2026, creators have actually attempted to burn their channels, intentionally posting low-quality content to drive down the valuation during the divorce process, only to face legal repercussions for wasteful dissipation of marital assets. Then there is the issue of likeness rights in AI. By 2026, the ability to license one's voice and image to AI companies for training or digital twins has become a significant source of passive retirement income. If Jordan has signed a 10-year deal with a tech firm to allow an AI version of them to teach engineering courses in multiple languages, that contract is a fixed financial asset. In a divorce, Taylor might be awarded half of the royalties from Jordan's digital ghost. This creates a scenario where a person is legally divorced, but their digital image is still married to their ex-spouse's bank account for the duration of the contract. We must also examine the demographic of the micro-influencer retiree. It isn't just the megastars facing this. Even professionals like doctors, lawyers, and real estate agents now have digital footprints that generate leads. If a high-end realtor in Miami has a TikTok following that brings in 80% of their business, that following is part of their professional goodwill. In 2026, divorce courts are increasingly distinguishing between enterprise goodwill, which belongs to a business, and personal goodwill, which belongs to the individual. If the followers are there for the Florida lifestyle tips, it might be marital. If they are there for the realtor-specific personality, it might be separate. The fight over where one ends and the other begins is the most expensive part of the 2026 legal discovery process. Furthermore, we are seeing the rise of the intellectual property trust. To avoid the mess of a direct split, savvy creators are moving their IP into trusts before marriage. However, in 2026, many of these trusts are being challenged as fraudulent transfers if they were set up shortly before a separation. The data suggests that for the demographic of earners aged 25 to 40, IP is often more valuable than their 401k. While a 401k has a ceiling based on IRS contribution limits, the upside of a digital asset is theoretically infinite. This makes the negotiation much more aggressive. Consider the scenario of the forgotten library. Many creators have hundreds of old videos that continue to earn small amounts of ad revenue every month. This is the 2026 version of an annuity. In a divorce, these back catalogs must be valued. Historical trends show that attorneys are now hiring specialized digital brokers to appraise the resale value of YouTube channels, even if the creator has no intention of selling. This appraisal sets the benchmark for the settlement. If the library is valued at $500,000, Jordan might have to liquidate part of their 401k just to buy out Taylor's interest in those old videos. The demographic impact of this is profound. We are seeing a digital prenup boom. In 2026, it is standard practice for influencers and creators to sign agreements that specifically list their social media handles, email lists, and domain names as separate property. Without these documents, the division of the digital soul can result in the total destruction of the brand, as the legal fees and the emotional toll of the creative capture lead to burnout. But the most complex part of this intersection isn't just the money, it's the control. If Taylor owns 50% of the brand, does Taylor have the right to veto a sponsorship deal? Does Taylor have a say in the editorial direction of the channel? In 2026, we are seeing management clauses in divorce decrees where the non-creator spouse is strictly prohibited from interfering with the business, but they are granted audit rights to ensure the creator isn't hiding income. This turns every tax season into a potential courtroom battle. As we move deeper into this masterclass, we have traveled from the simple 401k to the corporate boardroom, and now into the very identity of the modern worker. The demographics of wealth have shifted from things we own to who we are. But there is one final piece of the puzzle that almost everyone forgets. It is the silent partner in every marriage and every divorce: the Social Security Administration and the hidden benefits of the ex-spouse. In the next part, we are going to look at the spousal Social Security trap. We will explore how your 401k divorce affects your government benefits and why the 10-year rule is the most important date on your calendar if you want to protect your future. We will uncover how the demographic of the long-term divorcee is actually outperforming the short-term divorcee in retirement security due to a little-known federal loophole. If you think the government doesn't care about your divorce, you are about to see just how much is at stake. The final demographic shift we must analyze in 2026 isn't found in your 401k statement or your brokerage account. It is found in the Federal Code of the Social Security Administration. While private retirement assets like 401ks are divisible marital property, Social Security is a federal entitlement that cannot be divided by a state court judge. However, it can be claimed by an ex-spouse, and in 2026 the demographics of the long-term divorcee are leveraging a little-known federal framework to effectively double-dip into the retirement system without taking a single cent from their former partner. This is the 10-year rule, and in the current economy, it is the most valuable hidden asset in America. Plus one. Imagine a woman named Linda. She is 65 years old in 2026 and was married to her ex-husband Robert for exactly 10 years and 2 months before they divorced in the early 2000s. Robert was a high earner who maximized his Social Security contributions for decades, while Linda spent years working part-time or in lower-paying service roles. Under federal law, Linda is entitled to a divorced spousal benefit that can be as high as 50% of Robert's full retirement age benefit. Here is the demographic shocker. Robert doesn't even have to know. In 2026, the Social Security Administration maintains a strict firewall. If Linda goes to the local office with her marriage certificate and divorce decree, she can claim her benefit based on Robert's record, and the government will never notify him. Furthermore, her claim has zero impact on Robert's own monthly check. If Robert has since remarried, both Linda and his current wife can simultaneously collect benefits based on his record. This isn't a zero-sum game. It is a federal expansion of wealth that most divorcing couples fail to include in their long-term 2026 projections. Plus one. Step by step, the eligibility for this demographic loophole requires meeting 4 strict criteria. First, the marriage must have lasted at least 10 consecutive years. Historical trends show a spike in strategic delay divorces where couples who have reached year 9 of a marriage intentionally slow-walk their legal proceedings to hit the 120-month mark. Second, the person claiming must be at least 62 years old and currently unmarried. Third, the ex-spouse must be eligible for benefits. In 2026, a critical update to the deemed filing rules means that if you were born after 1954, you are automatically deemed to be filing for both your own benefit and the spousal benefit, and the government will simply pay you whichever is higher. Plus 2. Fourth, and most importantly for 2026, is the 2-year rule. If Robert has not yet retired but is eligible to do so, Linda can still claim on his record, but only if they have been divorced for at least 2 continuous years. This creates a demographic of patient claimants who finalize their 401k split today but wait for the 2-year federal clock to tick down before locking in their government-backed income stream. The data from early 2026 indicates that nearly 4 in 10 Americans nearing retirement are completely unaware of these provisions. This lack of knowledge leads to what we call the alimony valuation error. Imagine if Linda's divorce attorney negotiated for an extra $500 a month in alimony but gave up the 401k split. If the alimony ends when Robert dies or Linda reaches a certain age, she might lose out on the divorce survivor benefit. This is a separate, even more powerful demographic tool. If Robert passes away in 2026, Linda, as a qualifying ex-spouse, can claim 100% of his benefit amount as a survivor, provided she didn't remarry before age 60. In a high-inflation 2026 environment where the Social Security cost of living adjustment (COLA) has just increased by 2.8%, having access to a higher earner's base benefit is like having an inflation-protected annuity that you didn't have to pay for. But there is a trap in this demographic shift: the remarriage penalty. In 2026, we are seeing a rise in communal living among divorcees over 60. Why? Because if Linda remarries her new partner, she instantly loses her right to claim on Robert's high-earning record. For many in the 2026 demographic, the math of marriage no longer adds up. If Robert's 50% spousal benefit is worth $1,800 a month, but Linda's new partner only has a benefit of $1,000, Linda is effectively paying $800 a month to get remarried. This is creating a generation of Social Security celibates who choose long-term partnership without the legal marriage certificate to protect their federal retirement rights. Furthermore, we must look at how the 401k division interacts with these government benefits. In 2026, the Windfall Elimination Provision, or WEP, is a major concern for public employees like teachers or firefighters who also have 401k assets from private sector work. If you are a teacher with a state pension and you divorce a spouse with a high-earning 401k, the division of that 401k might seem like a win. However, the WEP can significantly reduce any Social Security benefits you might have earned yourself or through your ex-spouse. Most 2026 divorce settlements are Social Security blind, meaning they divide the 401k in a vacuum without realizing that the federal government is going to claw back a portion of the retirement income once the state pension kicks in. Case studies from recent 2026 filings also highlight the benefit suspension tactic. A high earner like Robert might choose to suspend his benefits at age 67 to earn delayed retirement credits, which increase his check by 8% every year until age 70. Historically, this would have frozen Linda's ability to claim on his record. But under the current 2026 rules, a divorced spouse can continue to receive their benefit, even if the worker spouse has suspended theirs. This is a massive demographic advantage for the divorcee over the current spouse, who is usually forced into suspension alongside their husband or wife. Plus one. The complexity of these federal rules means that the 2026 divorce is no longer just a state court matter. It is an intersection of the QDRO, the IRS, and the SSA. The demographic that succeeds in 2026 is the one that views retirement as a multi-layered cake. The 401k is the base, the performance equity is the filling, and the Social Security spousal benefit is the icing. If you only fight for the base, you are leaving half the cake on the table. But there is a darker side to this federal oversight. What happens when the government changes the rules mid-divorce? In 2026, there are active legislative discussions about raising the retirement age and potentially changing the 10-year rule to a 15-year rule to shore up the Social Security Trust Fund. For couples in the middle of a separation, these policy risks are the ultimate wild cards. As we move into the penultimate part of this masterclass, we are going to look at the global retirement war. We will explore what happens when the 401k is split between a spouse living in the US and a spouse who has moved abroad to geofire or retire early in a lower-cost country. We will uncover the tax treaty trap and how the IRS tracks your 401k distributions across borders. If you think the 10-year rule is a loophole, wait until you see how the 2026 demographic is using international residency to shield their retirement splits from the taxman. The concept of retirement in 2026 is no longer anchored to a rocking chair on a porch in Florida. We are seeing a massive demographic shift toward the global retiree individuals who, following a divorce, take their shared 401k assets and relocate to countries like Portugal, Mexico, or Thailand to stretch their dollars. This has created a new legal and financial theater, the international 401k divorce. When a 401k is split in a U.S. courtroom but one spouse is a non-resident alien or a permanent resident of another country, the IRS and the Global Tax Treaty Network become the primary protagonists in the story. Imagine a specialized consultant named Christopher, who has lived and worked in Chicago for 20 years. In early 2026, he and his spouse, Isabella, finalized their divorce. As part of the settlement, Isabella receives $800,000 from Christopher's 401k via a QDRO. However, Isabella is originally from Spain and decides to move back to Madrid immediately after the ink dries. She intends to live off the distributions from her newly created inherited IRA. This is where the 2026 demographic of the expatriate divorcee runs into the tax treaty trap. Under standard U.S. tax law, the IRS typically requires a 30% mandatory withholding on retirement distributions made to non-resident aliens. If Isabella is not careful, her $5,000 monthly distribution could be slashed to $3,500 before it even leaves the United States. However, historical trends in international tax law show that the U.S. has bilateral tax treaties with over 60 countries. In the case of Spain, the treaty may reduce that withholding to 15% or even zero, depending on how the distribution is classified. Step by step, Isabella must file Form W-8-BEN with her U.S. financial institution to claim treaty benefits. If she fails to do this correctly, or if her attorney didn't account for the withholding in the initial math of the divorce split, her standard of living in Madrid will be 30% lower than what she negotiated for in Chicago. Furthermore, we are seeing the rise of the geofire divorcee. These are individuals who realize that $1 million in a 401k is a modest sum in San Francisco but a king's ransom in Southeast Asia. By 2026, many divorcing Americans are using the portability of the 401k to arbitrage their lifestyle. They effectively split the asset, move to a low-cost jurisdiction, and use the lower cost of living to offset the fact that they only have half of their original nest egg. Case studies from 2026 show that this demographic is increasingly concerned with currency risk. If Isabella is receiving her 401k distributions in US dollars but paying her rent in euros, A 10% swing in the exchange rate can be more devastating than a stock market correction. Savvy international divorcees are now including currency stabilization clauses in their settlements or using specialized cross-border financial planners to hedge their retirement income against the volatile 2026 dollar. We must also look at the shadow residency phenomenon. Some individuals attempting to shield their 401k from a high-tax state like California or New York will move to a zero-income tax state like Florida or Texas just before the divorce is finalized. In 2026, we are seeing residency audits become a standard part of the divorce discovery process. If Christopher claims he is a resident of Florida to avoid Illinois state tax on his 401k split, Isabella's lawyers will look at his credit card swipes, his cell phone tower pings, and his utility bills to prove he was actually still living in Chicago. The demographic of the tax nomad is finding that in the digital age, it is nearly impossible to hide your true location from a determined forensic accountant. Then there is the issue of the foreign pension offset. In 2026, it is common for one spouse to have a US 401k while the other has a foreign retirement account, such as a UK pension, a Canadian RRSP, or an Australian superannuation fund. US divorce courts technically do not have the jurisdiction to issue a QDRO for a foreign account. A judge in Ohio cannot tell a bank in London what to do. This leads to the mirror order strategy. The couple must hire lawyers in both countries to draft two separate orders that mirror each other. If they don't, the spouse with the US assets might find their 401k being split while the other spouse keeps 100% of their foreign pension. Historical trends show that international asset leakage is one of the biggest reasons for lopsided settlements in the 2026 demographic. Step by step, the division of international retirement assets requires a specialized audit of the totalization agreements. These are federal agreements that prevent people from paying Social Security taxes to two countries on the same income. In a divorce, these agreements determine how credits for retirement are calculated. If Isabella worked in the US for 5 years and Spain for 15, her retirement security is a hybrid. If her U.S. divorce decree doesn't specifically address how her Social Security credits are treated under the U.S.-Spain totalization agreement, she could find herself ineligible for a full pension in either country. The data from 2026 also highlights a growing crisis for accidental Americans, people born in the U.S. but who have lived abroad their entire lives. When they divorce, they often discover that their foreign retirement accounts are considered passive foreign investment companies, or PFICs by the IRS. The tax penalties for owning a PFIC can be as high as 50% of the account value. If a divorcing spouse is awarded half of a PFIC without knowing the tax implications, they are inheriting a liability, not an asset. This is why tax indemnification has become a buzzword in the 2026 international divorce scene. One spouse agrees to give the other a portion of the retirement account, but only if they also sign a document promising to pay any back taxes or PFIC penalties associated with that account. Beyond the numbers, the demographic of the global 401k divorce is facing a jurisdictional race. In 2026, if Christopher thinks Isabella is about to file for divorce in Spain, where the laws might be more favorable to her regarding lifetime alimony, he might rush to file in Illinois first. This is known as forum shopping. The first person to file often gets to choose which country's laws will govern the 401k split. This has turned the end of a marriage into a tactical sprint to the courthouse, with international process servers and Hague Convention filings becoming routine parts of the 401k battleground. As we look at the complexity of the global landscape, it is clear that the 401k is the most portable, and therefore the most hunted asset in the world. It is the fuel for the expatriate dream, but it is also the primary target for tax authorities in multiple jurisdictions. The demographic that thrives in 2026 is the one that understands that a 401k is not a local asset. It is a global one. But as we reach the conclusion of this masterclass, there is one final question that remains. After the QDROs are signed, the taxes are withheld, the Social Security is claimed, and the international treaties are navigated, what does the end game look like? How do you actually rebuild? The 401k divorce is a demolition, but the 10th and final part of this series is about the reconstruction. We are going to look at the post-divorce recovery curve. We will examine how the 2026 demographic is using catch-up phase strategies to rebuild a $1 million nest egg in less than a decade. We will uncover the psychology of the reset and why some people end up wealthier after a 401k split than they were before. This is the blueprint for the 2026 comeback. The blueprint for the 2026 comeback begins with a radical shift in perspective, viewing the 401k split not as an end, but as a forced rebalancing of a life portfolio. In the final stage of this masterclass, we examine the post-divorce recovery curve, a phenomenon where individuals who have lost half their net worth manage to rebuild or even surpass their previous wealth levels. This isn't about luck. It is about the strategic application of the Secure Act 2.0 provisions, the psychological advantage of solo decision-making, and the optimization of catch-up mechanics that the modern American demographic is only just beginning to master. Imagine a project manager named Kevin. It is June 2026, and Kevin has just finalized a divorce that saw his $800,000 401k sliced down to $400,000. He is 50 years old, feeling the weight of the ticking clock. However, Kevin now has total control over his household cash flow for the first time in 20 years. Historical trends suggest that the single biggest obstacle to 401k growth in a marriage is often conflicting risk tolerances or divergent spending goals. Without the friction of a partner who might prefer immediate consumption over long-term deferral, Kevin can now pivot to a hyper-aggressive recovery stance. Step 1 in the 2026 comeback is the utilization of the super catch-up contribution. Under the latest IRS regulations, individuals aged 60 through 63 can now contribute significantly more to their 401ks than ever before. While Kevin is only 50, he begins by maximizing his standard base contribution of $23,500 and his current age 50 catch-up of $7,500. By 2026, many employer plans have also adopted the automated Roth conversion feature. Kevin decides to divert all his future contributions into a Roth 401k. While he loses the immediate tax break, he is effectively shielding his recovery from future tax hikes. Since he is currently in a lower tax bracket as a single filer than he was as a joint filer, this is a demographic masterstroke. He is buying his future tax freedom at a discount. Beyond the math, there is the psychology of the reset. Case studies of successful post-divorce retirees show that the loss of half an account often triggers a scarcity drive that results in higher savings rates than the individual ever maintained during the marriage. Kevin, who previously saved 10% of his income, now finds he can live comfortably while saving 25%. This isn't just about cutting expenses. It's about the velocity of recovery. When you combine a high savings rate with the compound growth of a $400,000 base, the potential outcomes for the next 15 years are staggering. If Kevin achieves an average 7% return while contributing $31,000 annually, his account could return to its original $800,000 level in roughly 7 years, and potentially exceed $1.5 million by the time he reaches 65. Another pillar of the 2026 reconstruction is the household downsize reinvestment. For many in the gray divorce demographic, the family home was a massive, illiquid drag on their retirement potential. By selling the large suburban house and moving into a high-density, low-maintenance urban condo or a smaller rental, individuals are unlocking massive amounts of home equity. In 2026, we are seeing a trend where divorcees take the $200,000 or $300,000 in cash from a house sale, and instead of buying more real estate, they use it to bridge their lifestyle while they max out every available tax-advantaged vehicle. They are essentially converting bricks and mortar into a liquid, diversified 401k or IRA engine. We must also address the health-wealth connection. In 2026, the demographic of the successful divorcee is heavily invested in longevity. Why? Because every extra year of work life, added to the back end of a career, has a multiplier effect on a 401k. If Kevin decides to work until 68 instead of 65, those 3 extra years of contributions and compound growth can add hundreds of thousands of dollars to his final balance. Historical trends show that post-divorce individuals who focus on physical wellness often have longer, higher-earning career arcs because they avoid the mid-60s burnout that plagues those in high-stress, unhappy domestic situations. Furthermore, the 2026 comeback leverages the Social Security pivot. As we discussed in earlier parts, the ability to claim a spousal benefit can act as a floor for Kevin's retirement. Knowing that he has a guaranteed government check coming based on his or his ex-wife's record allows him to take more calculated risks with his 401k investments. Instead of shifting to 40% bonds at age 55, he might stay at 80% equities, knowing his Social Security provides the stability. This risk-adjusted recovery is how the 2026 demographic is outperforming the traditional, conservative retirement models of their parents. However, we must look at the lifestyle inflation trap. In the wake of a 401k split, many people feel a desire to treat themselves to compensate for the emotional trauma of the divorce. In 2026, the luxury travel and high-end automotive sectors are seeing a surge in spending from newly single Gen Zers. The blueprint for the comeback requires resisting this urge for at least 36 months. Data suggests that the first 3 years post-divorce are the critical rebuilding window. If you lose those 3 years to high-consumption lifestyle shifts, the compounding math never catches up. The case studies of those who end up wealthier after divorce are almost always those who maintained a monk-like financial focus during that initial window. Step by step, the reconstruction looks like this. First, a total audit of the new single tax bracket reality. Second, the immediate maximization of all employer-sponsored accounts, including the use of health savings accounts, HSAs, as a stealth IRA for future medical costs. Third, a total reassessment of risk tolerance. Many divorcees realize they were investing too conservatively because of a spouse's fears. 2026 is the year they reclaim their own investment identity. As we conclude this 10-part deep dive, the landscape of the 401k divorce in America has been revealed as a complex, high-stakes evolution of wealth. We have traveled from the initial shock of the filing and the technical nightmare of the QDRO to the executive shadow plans, the global tax treaties, and finally the psychological rebuild. The demographics are changing because the American worker is changing. We are no longer passive participants in a corporate pension. We are the active managers of our own survival. The 401k divorce is not just a legal event. It is a structural transformation of your future. Those who approach it with data, technical precision, and a long-term strategic lens are not just surviving the split, they are mastering it. In 2026, the goal is no longer just to keep half. The goal is to build a foundation that is stronger, leaner, and more resilient than the one you left behind. But even as you master the 401k, a new challenge is emerging on the horizon. As the 2026 tax landscape continues to shift, a new form of wealth preservation is taking hold among high-net-worth individuals that goes beyond the 401k entirely. In our next series, we will investigate the rise of the private family bank and how the next generation is bypassing the traditional retirement system altogether to shield their assets from the volatility of the American court system. If you thought the 401k was the ultimate fortress, wait until you see what comes next. The game of wealth is changing again, and the next chapter is already being written.